Good morning, everyone. Make sure that I'm.
Good morning. Good morning.
Okay, good. Marjorie, I see that you signed on twice. I guess that's deliberate. Marjorie?
Yeah, I do. I my Canada.
All right, she signed on twice, but I'm not sure that she's here at all.
Yes, good morning.
Okay, all right.
I'm sorry, I'm actually signed on twice because I'm going to be in motion.
Yeah.
I'm in the middle of a project that's time sensitive for
Okay,
clients.
so make sure you keep your mic off because you'll get an echo if you signed on
Yes.
twice in the same place.
Yes, I'm going to sign it off as soon as I get on the road. But just to
Okay.
let you know, I've been here. Okay, I'm listening.
Not a problem. So let me make sure that yeah. So good day, everyone. We're missing quite a lot of folks, but it is 5 after, so we're going to get started. We are honored this morning to have attorney Elton Gibson joining us, and we have sort of loaded the gates with questions that you have put together that I'd sent to him. And he has those questions. I think a few more came in since then, I think yesterday, that I didn't forward to him. But we're gonna formulate this in terms of a dialogue. And I am going to turn it over to Mr. Gibson for him to, sorry, for him to, boy, for him to introduce himself and for us to get started. I suspect as these things go that we think we have a lot of time to get through stuff, and we tend to not have as much time as we think. So I'd like us to get started. I'm going to turn over the entire thing to Mr. Gibson, and he will tell you how he would like to proceed. Before he starts, anything anyone has to ask in general about the class, or any comments about the assignments? Okay, the silence, Cleophas.
Yeah, I saw you, it was a quiz, I think.
Yeah, there's a quiz that's, yeah, let me mention, there's a quiz that's due at 1 minute to midnight tonight.
Okay.
It's a quiz on the user experience, which I think is lesson 10, the user experience.
Okay.
So yeah, it's a quiz on that, and it's a half-hour time quiz. So because it's due at 1 minute to midnight, please don't start it like 5 to midnight, because that's not going to be very helpful. Okay, so we can begin. I am going to allow Mr. Gibson to introduce himself. And I'll set one little rule that everyone who's going to speak today, if you can just turn on your, the video sometimes causes Zoom to not perform properly, but if you can turn on your video for 2 seconds or so everyone can see you for, and if Mr. Gibson likes, he can keep his video on. But while you're speaking, if you can turn on your video for a little while so you can see who's talking, that would be much appreciated. Remember, we also have the comment box. So if you have, while someone is speaking, if you don't want to interrupt them, or if you have an idea or something, you can also throw that in the comment box as well. And we try to keep an eye on those. So without much further ado, I'll turn this over to Elton and welcome him to this course. I'd just like to say, Elton, we have a group of professionals, young professionals here that they have a lot of different backgrounds, but they're all focused on trying to be professional property managers. So you're in good company.
Okay, great.
Okay.
Okay, good morning all. I'll keep my video on just for the introduction. Well, my name is Elton Gibson, as Mr. Fernando mentioned. I'm primarily a real estate attorney. So my specialty is conveyancing mortgages. I also practice in the area of corporate law as well, so company operations and administration. I am the principal of Amicus Chambers. I've spent some time at the Central Bank, where I've worked along with Mr. Fernando. He's, well, was a wonderful mentor to me. So thank you for that, Mr. Fernando. So we're going to talk today. What I prefer is that, like I told Mr. Fernando, that we can have a conversation. If you have a question, so I guess whoever's here now, you can ask questions and we can just talk about it. We can talk about the law. Just one caveat, and the caveat is that I'm not a litigator. And normally litigators are litigators are the ones that deal with problems when it comes to landlord and tenant. All right. So for me, if someone comes to me, they would probably want a lease agreement to be drafted. Now, it is my as an attorney, I need to understand their needs and to draft that in such a way as to kind of have an idea of what problems may arise. But we can still talk about the law, and the law of landlord and tenant is voluminous. I mean, there's so many things that can go wrong. But I guess that's just that caveat. We can still discuss it. But yeah, so if you have anyone that has a question, you can ask your first question and we can start our discussion.
Well, Ian, are we going to use the same question? I mean, I know you have a listing of questions that we had submitted. Are you going to refer that to Mr. Gibson?
It's up to you. Do you guys prefer that? You prefer me to go through the questions here because these might be your questions. So if you want your question answered, you can tell me which one is your question and whether someone may yeah.
Yeah, because Elton, we submitted a listing of questions to Ian,
Uh-huh.
and I mean, it's just a matter of order. I guess it's the same
Okay.
questions that we'll pose.
Okay.
Yeah,
In the forum.
yeah, Elton, we can go through the questions that we have because they came from this group. So
Okay, good. Okay, so let's start with question number one. And I'll just turn my video off if you guys don't mind. Okay, so question number one, can a lawyer or attorney act on behalf of the property manager and evict a tenant? If so, what is the process? I want to say this too. Okay, I mean, what I would like to have something that's interactive. I want to know what you guys are thinking as well, because some of these questions are a bit dynamic, and I don't want to be the only one talking. Okay.
Right.
Okay. So the process so yes, the short answer is yes. And it's probably best to retain an attorney when you want to well, let me start over. Basically, the process of evicting the tenant is that you provide the tenant with notice, and the notice period, and this is where you have to actually have an idea of what the lease agreement says, because some lease agreements would say that well, there's sometimes a notice period. All right, so you have to be aware of that. So that's one, especially when there isn't a breach. All right, so let's just say there's a breach scenario. You want to again look at the agreement to see whether or not this particular breach is something contemplated by the lease, or if it's a breach contemplated by the common law. Just a breach that may not be explicitly stated in the lease agreement, but it's implied. So when you go to the attorney would definitely want to have a copy of the lease agreement, because he's going to want to have an understanding: is this act or this potential breach capable of canceling the lease agreement? If it is, the attorney would prepare what's called a writ of summons, and all lease landlord tenant matters goes to the magistrate court. That's the magistrate court has jurisdiction over these type of matters. So he would prepare a writ of summons stating the lease agreement, stating the breach. That writ of summons is then filed with the magistrate. A date is obtained, and the writ of summons is served on the tenant, and the tenant has to appear before the court to, I guess, answer whatever allegation is made or allegations are made in the writ of summons. So that's the basic process of an eviction. Any questions? Anything
Right.
anyone
So
wants to-
Elton, what you're saying is that even if you submit a notice of eviction, let's say, for instance, the client or the tenant did something contrary to what you think is fair and reasonable, and you want the client gone, the court could overrule you and say that's not sufficient grounds to evict.
Yeah. So basically, okay. So sorry, go on.
No, I'm saying, the question is, could the court overrule your eviction notice? I mean, could the court rule in favor of the tenant and say you have no grounds to evict?
So that's a good question. So basically, let's just say you draft your eviction notice to say that for non-payment of rent, all right, you are being evicted. If you go to court and the court finds out the tenant has been paying rent, then yeah, it's going to be overruled. So this is again key on how you draft your notice to evict, and also the terms of the lease. So for example, the lease may say, and my leases, what I try to do is I try to give both parties a way out. So if it's even, so for example, let's just say you have a yearly tenancy. I always, depending on who I'm drafting in favor of, I give them a window to say we can cancel this by giving the other 1 month, 2 months, 3 months notice. All right. So when you draft your eviction notice, you want to be able to say whether there's a breach, and even if you're allowed to kind of cancel the lease within that period, you can do that as well. Now, notice, just to let you know, if there is a notice period, you have to respect that. You have to respect that notice period. So if the lease says 3 months, then you have to respect that. So to answer your question, the court will look at the reason for the eviction. And if the reason isn't valid, then yes, the court can overrule or say that the eviction notice is a bad notice.
Right, because I mean, there are instances where persons, because they wanted to, a higher level of clientele for property, they wanted to evict the current tenants. So
Right.
I guess on those grounds, you pretty much you have tenants on your property, which you can't evict.
Well, basically, remember now,
the basis.
this is a contract, and the contract rules. The contract should speak to how and when the contract should be canceled. All right. So one, you're protecting the landlord, but you're also protecting the tenant. And I think the law recognizes that a tenant having to pack up and move it can be onerous.
Yeah.
So you want to give the tenant some protection as well. All right. So this is where if you're representing a landlord, you have to draft your attorneys would draft the lease agreement in a way that if the landlord wants to get out of this contract, this agreement, that they can do so easily. So that's where this all begins. I mean, I always tell people, whatever agreement you go into, you don't just think about what you're doing today. You think about, how do I get out of this as well? If you know.
But have you ever experienced the tenants bringing an action against the landlord? Let's say a landlord is nasty. I mean, like in the papers, you have a bunch of landlords who do some strange things, like cut off this and cut off that and put locks on the premises. Has there been cases where the tenant has brought an action against the landlord for crafty conduct or unbecoming conduct?
Now, I'm not a litigator, so I can't tell you that I've experienced that. But what I will tell you is that, I mean, landlord and tenant cases there's so many landlord and tenant cases. I mean, I think that's probably one of the biggest areas of the law in some jurisdictions. So it probably it does happen. I'm sure it does, and I'm sure the law favors the tenant, where, as I said, the contract is used against them, or the landlord hasn't abided by the terms of the contract. But I can't tell you that I've ever experienced it, but I'm sure that there are many cases where it has happened.
Marjorie has a question.
Yes, well, pretty much. Sorry, I'm stealing a moment. Hello, Mr. Gibson and the rest of our class. And thank you for this morning. I was just asking, actually following up on Kevin's question about the tenant. So here's another twist on it. What if the tenant has not signed a lease due to the fact that the agreement itself doesn't seem to have been met? But they have moved into the dwelling. What would the ramifications be if there was any?
That's an interesting question, because okay, so let's just say there's a draft agreement, all right, and the tenant says, I mean, I don't know, I don't agree with the terms, but yet they still move in. I mean, that's a weird scenario, because the act of moving in suggests that you agree to. I mean, that you agree to the term. I mean, if you I guess you agree to the terms. I mean, you can't have it both ways. So it's like, so for example, so let's look at basic contract law. So you have offer, and then you have a counter offer, or you have offer and you have acceptance, and you can accept an offer based on your conduct. So to my mind, if you have a draft, I send you the draft, and you move in, I allow you to move in, your conduct suggests that you agree to my draft. So afterwards, you can't tell me, well, I don't want A, I don't want B. I mean, you're actually in my place, or you're actually in the landlord's place. So any amendment to the draft would be considered a counter offer. Now, if the landlord allows the person to stay in, the question is, does the landlord accept that counter offer? So the tenant says, I don't want to pay $1,200. I want to pay $1,000, and the landlord allows the tenant to stay. The landlord then accepts that counter offer. So this is where the landlord has to say, no, you have to get out of my, you have to leave. So you have to be aware of situations like that. So like I said, remember now, a lease agreement is a contract. So basic contract principles will come into play. So yeah.
Okay, so and the fact that the lease itself, according to the tenant, the lease itself says that they have not met the
Mhm.
lease conditions. For example, there's no water, for
Right.
example.
Okay. Right. Right.
That's even in the lease, or what did she say? Or something like, what was another thing? The electricity is not permanent, something like this. It's
Mhm.
just on a temporary to
Mhm.
loop. And so she's holding back on making the signature and the deposit.
Right.
What would that be the same as what you just stated?
Okay, so let's walk through that. So basically, you're saying that the landlord is responsible for paying the electricity or connecting the electricity, and that has not been done.
Right, that, and there's no water.
And there's no water, all right? And so the tenant is saying, I'm going to stay here, but I am not going to pay the rent and the security deposit
Until it's done.
until it's done. Okay, so well, that's an interesting scenario. So basically, both parties are now in breach. All right.
Okay.
So what I would say is, I think one party has to put an end to this stalemate. Okay, so for me, right? Okay, I would say that the as long as the tenant is living in is living on the premises, the tenant should pay something. Now the landlord is in breach. So what is the tenant's right? What are their rights and obligations? Their right probably is to one, rescind the agreement. Two, I mean, they can go to court, but then what will the court say? Especially if it's only been 2 months, the court can order the landlord to turn on to turn on the electricity, to rectify the breach. But the tenant will still have to pay at some point in any event. Yeah, so it's I don't know, that's a real tricky situation. I would say one party would have to end it by probably rescinding the contract. I think that's the cleanest way to do it. If the landlord cannot satisfy the requirements under the lease, I would say too, and I know there's questions about also about ethics in your class. I think it's unethical to basically allow a tenant to move in if you haven't satisfied those fundamental elements of the contract. You know, so it doesn't look good for the landlord, to my mind at least.
Thank you so much, sir. Thank you so much.
Cleophas? Cleophas, if you're speaking, you're muted.
I'm trying to find the question I sent to you. Give me a sec. Okay, we're talking about real property and how to create a trust for the property and have multiple properties in the trust, but managed separately. How does that work exactly?
Okay, which number is that? What number? I think I read that.
I'm not sure, but I think that
Okay.
came from.
Oh, sorry, yeah, that's Mr. Okay, that's fine. Let me just get let me read the question because I thought it was an interesting question when I read it the other day. Okay, so let me read the question for the benefit of everyone. In lesson 3 of the book, there's mention that if you have real property, you can create a trust for the property and have multiple properties in the trust, but managed separately. How does this work exactly? Would I need lawyers or bankers for this? Okay, so trust law and trust can be very complex. All right, and so to answer the last question first, definitely you need to get lawyers involved when drafting trust, when seeking advice on trust. All right, so that's one. So let's talk about, one, do you guys understand the trust concept? All right, so for example, if I asked you, is a trust a legal person, what would you say, Cleophas? I'll put you on the spot since it's your question. Let me ask you this in another way. Is a trust capable of holding property?
Yes.
How so?
That's what I'm trying to figure out. I
Okay,
know
good.
with
Okay,
my,
that's
with my
go on.
in my situation, I have
Mhm.
an LLC,
Right.
and the actual property management business I have is like underneath the LLC. So
Okay, good.
it's not in my name, it's in the
Right.
LLC name. So I'm trying to figure out if that's my trust company, or should I
Right.
put something above the LLC that holds the
Right.
LLC that holds my business.
So, okay, that's a wonderful way to start. So a trust is fundamentally different from, well, as you say, a limited liability company. In the Bahamas, we don't call them LLCs. In the United States, they call them LLCs. We call them, companies are companies or IBCs. Well, companies basically. But so a trust is fundamentally different. Well, let me take that back. They're fundamentally different, but the same. It's different in that a trust is not a legal person. All right, a company is. So a company is capable of holding property or assets in its own name, just like a natural individual. A trust is not. So let's walk out the fundamentals of a trust. So basically, what a trust is a relationship between certain parties, all right, and as to the legal and beneficial interest in an asset. So let's walk through that. Let's say you, Cleophas, you're called a settler. So you are the person that owns property A, Life and Key. And you, for whatever purpose, well, let's say this first. So trust can be used for certain purposes. One, a trust avoid probate of estates. And the reason why is that a trust is what they call an inter vivos, so a life gift to another person. So it's a gift it's a gift it's a gift during the life of these parties. It's like a conveyance or any other document like that. So Cleophas, you are the settler. You're the person that owns this property. All right. And what you do is you basically transfer the legal title to this property to a trust company like RBC Trust or Equity Bank or one of those trust companies, or to an individual. And you tell that individual, I want you to hold this property for the benefit of my beneficiaries. For example, your children. All right. And so what you've done is you've separated yourself, your legal interest and your beneficial interest from that property. You can no longer deal with that property, all right, yourself. Your trustee is the person or entity that deals with this property. So for example, you can give cash, you can give property to this person, and that person can manage those assets for the benefit of the beneficiaries. So you see a lot of rich people, they tend to create trust because one, primarily, well, in Europe, etc., for tax purposes. Because if they own this property, they're going to, in their own name, they're going to be taxed. All right. So they tell the tax authorities, I don't own it. I don't have the legal interest in this property anymore. All right. My trustee does. And my trustee basically has responsibility for the management of it, for the caretaking of it. All right. So it's a legal separation in that regard. The trustee is the entity or the individual that has title to the asset. Okay. So as I said, the legal interest is separated from the settler. Okay, and that legal interest is given to the trustee. So the trustee owns, on paper, this property, this asset, but he owns it for the benefit of the beneficiaries. So the question is, you want to know if you can have multiple properties as a part of this, as part of this device or part of the scheme, and yes, you can. So the settler can have multiple properties, and he can convey all of those properties to the trustee. And the trustee can hold all those properties in trust for the beneficiary. And so, for example, let's just say the trustee would now be the person that comes to you, Cleophas, as the property manager, because he's the legal owner. He's responsible for the management and caretaking of this property. And he hires you, and he says to you, Cleophas, I want you to be my agent of these 5 properties in the Bahamas. All right, or of this one property in the Bahamas, whatever, Let's say the settler has owned 5 properties, or the trust holds 5 properties as a part of his assets. 1, the settler lives in. 2, they basically travel to every once in a while, and the other 2, they want to be rented. All right, so he would basically tell you, I want you to be the property manager for these 2 or these 4 properties, And I want you to just, I mean, whatever you do, just manage to rent them out to whoever, you know. So that's basic. That's the basic kind of relationship of a trust. I hope that I hope you understand that. I mean, I hope that I hope that's clear, or sort of clear.
Okay. Okay. In a specific situation, like you said,
Mhm.
parent, let's say a parental situation where a
Mhm.
parent has let's say a building, but
Mhm.
has multiple kids,
Right.
but only one of the kids is like interested in running the business or this and that.
Mhm.
Can they use the trust to come to agreement to where like the kid wants to protect himself to say, hey, if anything happens to you,
Mhm.
and I'm not sure if you have a will, can we use this trust to where the business turns over directly to the child or to the person?
I guess you can, but I wouldn't use a trust I wouldn't myself use a trust for that purpose, unless, for example, um, okay, so you have what's called discretionary trust, right? So that what that means is that either the settler himself or the trustee has power to apportion, what they call apportion, or to give more of the assets to a particular child than the others. All right. So, for example, the standard way a trust is run is that, like I said, the settler has no decision-making capacity with respect to those assets anymore. He's transferred his legal interest. All right. But you do have certain trusts where the settler retains certain powers. All right. Those trusts can be problematic sometimes, and we'll deal with that later. But so the settler can say to the trustee, in the event of my demise or whatever, I want child A to get more or less or whatever. You know what I mean? So that can happen. I think it's an expensive way to achieve that. I think a more simple way to do it is by way of a will. You'll probably pay $100 for a will, you know. But of course, the will has to be probated. Yeah. So, but it can happen. But I think it's, like I said, it's a probably an expensive way to do it. All right.
Okay, thanks. I mean, I do have a next question, but I'll let someone else go in between.
I'm not sure if Kevin still has a question, but he's
Right,
put
I'll
his
just-
hand.
Right, I'll just probably piggybacking on Cleophas' comment in regards to trust. So pretty much, Elton, as property managers, we are really, in some instances, right, or in this world, we wouldn't be ordinarily dealing with an individual. We'd be dealing with a trust, with a trustee. And you're saying a trustee is not a legal person. A trustee is only a tool by which, it's only a means by which the wishes of the owner is executed. So when we're dealing with trust property, the person that we're dealing with is the trust company then. So we'll be dealing with the trust company and not any owner per se.
Okay, so let's clarify that. So a trustee is always a legal person. So it's a company or it's an individual, a trustee.
The trustee.
All right, you're right. So the trust concept, generally speaking, is not a legal person. So for example, so in terms of transferring a property to a trust or to a, right, what happens is that I, or Cleophas would convey by virtue of a conveyance, and you guys all know what a conveyance is. I know. He will convey title to that property to the trustee. All right, and that creates the trust, and that creates a bare trust, a simple trust. I convey, or I can give my property to Cleophas, and I can say, I want Cleophas to hold this property on trust for my child. That's a trust. And in the document, you will see the language is clear that I'm conveying it to Cleophas as trustee for the benefit of my child. So the trustee is the individual or is the company that has the legal estate. So he would be responsible for anything related to that property. So he's basically the legal owner, but not the beneficial owner. All right. So let me take a step back. Whenever you own anything, you are the legal and beneficial owner. All right, but they say that you own it in law and you own it in equity. All right, what a trust does, it splits those two concepts. It gives the legal owner, or it gives the trustee the legal estate. It gives the beneficiary the beneficial estate, and the beneficiary has certain rights because that asset has to be used for that beneficiary's benefit. And if it isn't, the beneficiary has a claim against the trustee. As trust law is kind of technical, and yeah, it is kind of technical. So I was surprised to see the question on trust, but it is, yeah. I mean, and this is why I say you have to get a lawyer involved when you're dealing with trust. You have to. It's a must.
Marjorie, there's Marjorie and Kevin want to say something, and I also see Blair has a question. She says her mic isn't working, so let me ask Blair's question for her. She's saying that can a trustee be an individual or a company? That now the trustee, yeah, can a trustee be a company or does it have to be an individual?
Yeah, it can be an individual or a company. So remember, companies, like I said, Cleopas had a good question about this limited liability company. A company is a legal person, okay, capable of taking title to assets in their own name. So like in the Bahamas, we have a lot of trust companies. I mean, there's so many, equity and yeah, there's so many. And so they are companies, they are limited liability companies, and they hold the asset. They act as trustees for persons who want to create trust. So yes, they can be an individual or a company. I see another question. Sorry, before you go on, Ian, if you don't mind, can you give something to yourself? Good question again. For normally no, normally no. But for the basis of a trust, can you create a trust and be the settler and the trustee? And yes, you can, because you're separating the legal and beneficial interest. So you can be a trustee of your own trust, as long as there are multiple beneficiaries, though. All right, so let's say you have your spouse and your children as beneficiaries, then yes.
Audrey, you had something?
Yes, actually, it was just triggered by Mr. Gibson's when he mentioned that the trustee, the person who's holding the trust for the recipient or the beneficiary, what in the case should, say, the benefactor pass away? What would be the next step? Like, what would be is that accounted for in this document?
Very good question.
Let me add before Elton answers that, because we have a couple of questions that kind of have fingers into this particular dialogue we're having. One of those questions is about whether the property manager who's been given a property manager, I think it's the question about if something happens to the owner, what rights or what privileges, if any, can this property manager now assume, given that the owner is demised or something else? That's one of the questions that seem to touch on to what we're talking about. And then the other question, I think, comes from the same question we started here with, which is a question about is it okay for me to hide my identity from my tenants, given that the tenant is signing an agreement with someone? Does that tenant, can I kind of hide from the tenant and the tenant not really know who they're signing the agreement with? But anyway, that's a couple of questions. Marjorie, let me let you ask yours.
Okay.
Marjorie?
So yeah, if you could repeat your question, Marjorie, please.
Oh, sorry. Yes, so my question is primarily
I can remember.
with the trust, with what Mr. Gibson said about a trustee being the owner of the trust, but not the benefactor, what happens in the event of the death of the benefactor? How is that? How does it move forward from there?
Okay, so the benefactor being, I'm being the beneficiary, Marjorie?
Beneficiary, yes, yes.
Okay,
yes.
good. Okay. So basically a good trust agreement will definitely set out what happens on the demise of a beneficiary. So normally, so let's just say let's say you have 3 beneficiaries. Well, just like in a will, it may say, for example, if one beneficiary dies, then that beneficiary share goes to the remaining of the the remaining beneficiaries, the ones that are alive. That's one. Another thing, it may say that it may go to the beneficiaries of children, their share. So a good trust document will definitely set out those details. And there are a lot of cases that deal with that. For example, let's just say there aren't any beneficiaries alive. The question is, like, does it go to a remoter issue, as they call it, like a cousin, or but the way a trust is drafted too, you have to have certainty of the beneficiaries. So, and there are a lot of interesting cases on it where, as I said, cousins or other persons try to come under the definition of the beneficiary within the trust document. All right.
Thank you. Thank you.
Okay.
Thank you.
So Elton, what about the question of
Okay.
the owner trying to, or needing or feeling the need to hide themselves from the tenants? There's some practical cases that we've discussed in class. For
Right.
instance, I know someone in class mentioned that they live on property with their tenants. I won't use the word pretending to be a tenant. They are actually on the property occupying one of the lodgings.
Right.
But they do not want the tenant to know that they are in fact the owner of this complex. So the question is that okay to do? And how do you achieve that legally and even ethically?
Okay, and I think it's an interesting question, and it's a matter of ethics to some degree. It is allowed to some extent. All right. So, for example, if the landlord can create so they can create a power of attorney. All right, and they can give the power to deal with this particular property to a third party. All right, that third party can then enter into, I guess, the lease agreement with the tenant. All right, if the landlord wants to shield himself, I would say that on the face of it, it seems unethical if you don't, if there isn't. Okay, so I mean, I'll tell you why. So this, again, we go back to the fact that this is a contract. All right, and being a contract, this is an agreement between 2 parties, and the 2 parties should know definitely who they're dealing with. They should know what rights and responsibilities they have with respect to each other and to the premises. So if this person does not have, so let's say the landlord uses some other third person. If this third person doesn't have a legal relationship with the property, then that's problematic, and to me, it's unethical. But if there's a legal relationship in that, so one, the landlord gives this power, to a donee, or the landlord, for example, incorporates a company, and the company is the owner of the premises. That shields the landlord to some degree. So that's what I would say. I would say definitely have if there's another legal relationship that exists that allows the landlord the anonymity that he or she wants, then I think that would achieve that purpose. But an outright, I don't understand how they would enter into the contract otherwise. Like what would be like who would be the landlord under those circumstances?
Okay, okay, thank you. What about the other question about, okay, I have 5 properties. I want to set up each one as a under a different company, but I still want those 5 properties I want them to operate differently. Their own financial records, maybe their own property managers, their own stuff. But at the same time, I still want to be able to have them held under one place as mine. How does one achieve that?
Okay, when you say you want to have them under one place as yours, what do you mean by that?
Like we hear of something called a holding company.
Right.
Is that a way for me to have separate entities but hold them together under one umbrella somewhere else?
Okay, so let's talk about a holding company is simply a company that holds assets, as opposed to an operating company that's a business, that's a going concern. All right. So let's just say you have 5 holding companies that hold separate assets. All right. So that's fine. Each of those companies would have shareholders, and we can I'll just take a pin. I'll go back to that. And each of those companies will have directors. All right. Now let's just say the shareholders of all those companies are the same person, Ian Fernando. All right. What Ian can do is Ian can incorporate a buffer company. So a company that is the shareholder of those 5 companies. All right. And those 5 companies, and that company can also be the director of those 5 companies. So the board of directors of that, let's call that company A, that buffer company A. The board of directors of company A would be the controlling persons, the individuals that control all of the other companies. So what you has explained, Ian, was a group of companies, and many organizations, large organizations, employ that same they employ that mechanism or that scheme in order to manage their business affairs and their properties. So, for example, one of the clearest that comes to mind is the Atlantis structure. So Atlantis has 20 companies. Maybe about 10 companies holds different assets. All right. And then they have the management companies that actually manage those assets. And then they have, so imagine a tree. So it goes up where you have one company now that basically is responsible for the management of all of those companies. And the board of directors of that company they are responsible for managing all the companies that are underneath that management company. That's expensive, and that can be, but if you want to do it like that, that's the way it's done. So yeah, so it's basically a group of companies that you're explaining.
There's a question in the chat while we're on trust. Are there any requirements for someone to be a trustee?
Good question.
Or can anybody do this?
Anyone can be a trustee. The danger in being a trustee is that depending on what powers you have, any mistake that you make, you can be sued by the beneficiaries. So if you are a trustee of a portfolio of assets that's large, and if you have like investment powers, it's best that you either employ a professional investment company to kind of undertake those assets and to manage those assets, or you pass. Like, for example, like today, a lot of lawyers don't want to take on the role of trustee because it is very onerous, and you put yourself in a lot of peril if you mishandle those assets. All right, so to answer your question, yeah. So for example, let's just say your sister asks you to be the trustee of her child in the event of her demise or whatever, and the only asset is the house that goes to the child when the child is 18. Then that's fine, because your only task would be to kind of upkeep and manage the home. But if it gets complicated and complex, where there's cash and the cash is payable at certain times, then I would say it wouldn't be wise for untrained person to be a trustee.
Okay, thank you. Let's move on to another question of your choice, Elton.
Okay, so that was an interesting question. This is your question 15. Persons have a constitutional right against discrimination based on certain factors. So can a property manager ask prospective clients on an application form questions about age, sex, or ethnicity? I thought this was an interesting question because well, two things. Well, this person mentioned based on certain factors, and I was wondering whether or not they knew what those factors were. So if you look at the Constitution, let's start with this. The Constitution basically says specifically how you cannot be discriminated against, and I think it's race, creed, religion, and something else. I can't remember the third thing. I'll get it for you. But so the Constitution limits, all right, how a person cannot be discriminated against, and there are a number of cases that actually enforce that. So one of the things it doesn't state is, for example, disability. So there's a case maybe like 10 years ago where a person was arguing that a condominium association discriminated against them on the grounds of their disability because they needed an emotional dog. And the condominium's policy was that no pets are allowed. And what the court reaffirmed was that, there's nothing in the Constitution that says that you cannot be discriminated against based on ground of disability. So that's one. So always pay attention to that. So that's one. So another thing is we need to understand what's discrimination. So there's a legal definition of discrimination, or the constitutional definition of discrimination, and it is a dictionary definition of discrimination. And I mean, a landlord can be discriminating in terms of who they rent their premises to. Now, they can't discriminate based on the person's race, for example, right? They can't say because you are black, all right, or because you're white, we're not going to rent to you. But there are ways that you can still be discriminating. So I'm not sure if you guys employ forms, and in your forms you can ask questions about race, you can ask questions about sex or whatever. But the race or religion, for example, can't be the sole reason why you deny a person access or why you turn a person away from renting. I would say that it's good practice though to have a profile. And I'm sure you guys know, I'm probably not telling you anything you don't know, to have a profile of your tenants, because you don't want to necessarily rent to a tenant that can't pay the rent. All right, so your profile, your age, your sex, ethnicity, how much you make, where you lived before, all those things will give you a profile of this person, and based on that profile, you can deny that person. You can say, no, you're not the appropriate person that my client wants to rent to. Right?
Yeah, that's interesting. I think we've had some discussions on this because you have I think even the experience of some persons in this group where you would have a property owner, because they are of a certain age, may not wish persons to be of some alternate age group to be on their property. And we're not talking about minors. They may just not want anyone under the age of 40 on their property.
Right.
Because they are quite settled and only want settled people on their property. We encountered a phrase you use, which is a very key word. This is discriminating, where a person can use their discriminatory instincts to make choices about what they want, as opposed to, is that discrimination under the law, though? To say to a property manager, under no circumstances can you rent any of my units to someone who is under the age of 50 or under the age of 40?
Good question. So I'm going to look at the Constitution now, Article 26, if you guys want to look at it later, and just to see I'm sure age is not one of the factors.
It's not one of the factors for discrimination. Yeah.
No, and this is what I'd say. And when I read the question, I thought of a scenario. Imagine you have a, let's use the reverse. An 80-year-old man that wants to rent the top floor of a 3-story building that overlooks a harbor. He loves the views of the harbor. And the bottom floor, there's a pub that has karaoke 3 days out of the week. People get loud. Most of the people that rent within this building are 30-somethings, they have active lifestyles. And he tells you, I'm in the twilight of my life. I just want to chill. I don't want any disturbance. All right. All you know is that he's 80, and those are the factors. That's all you know. I mean, you can't just. I think it would be fair to disqualify him as a person that's going to rent this unit. I mean, he's not going to be satisfied with all of the circumstances that exist within this building. So I think you can discriminate. I think on the grounds of his age and I guess and his I guess what he's expecting, you can discriminate against him. So that's one. And then second,
there's a similar thing I have, Elton, which is even mentioned in the Constitution's religion. You may have a tenant who is, say, Jewish or some other religion that demarks a particular day of the week as their holy day.
Right.
And they're renting from you, and they say to you, well, look here, this is my holy day. I don't want no one making noise around me on that day. I'm supposed to be peace and quiet and And you guys are impinging on my religious freedom and my religious rights by having this pub open on my holy day. How does that work?
That's a good question. That's a good question. And let me say this, and I'll give you an example. There was a case, I think, years ago where a Rastafarian, I think it was a boy, wanted to go, I think QC, and he had locks. And the question was, if you can QC, was it Kingsway or QC? I can't remember the school, but can they tell him that he cannot come to school?
It was Kingsway.
It was Kingsway. All right. So the question was, were they discriminating against him on the ground of his religion? And so the same way in your scenario, is the discrimination on the ground that he's Jewish, or is it that the noise on his Sabbath is going to upset him? And the other tenants, that live in the building, they accept this noise, or they are part of this noise. So in my view, the discrimination isn't because of his religion. It isn't because he is Jewish or because he's a Rasta. It's because no one in the school, or the school policy is that no one can have locks, or the hair has to be a certain length. Here in your scenario, the discrimination is that you don't want noise on a Saturday or whatever day. And this is an active area. There's going to be noise. I can't tell 8 tenants that they cannot make noise just to satisfy you, or So I don't think it goes to the fact that that person is Jewish. It's another factor. It's another, it's something else that's preventing me, or that's letting me know that this isn't appropriate for you.
Okay.
What do you think? Disagree, agree?
Yeah, this is very touchy.
Yeah.
But because I think as we move on as professionals, we have to really come to grips with the fact that being discriminating, we have to make sure that we are not applying discrimination sometimes. And sometimes we have to also look at the avoidance of discrimination can sometimes be to our detriment, because there are cases where we are not really applying discrimination. But it is something that requires us to think. And exactly. I've been telling the class, one way to get around many things is to one, have things covered in your agreements, and to 2, have your agreements vetted by the legal profession who would be able to look at these nuances. For instance, if you put in your lease agreement, because you are, for instance, of a particular religion, as the property owner, And as the property owner, your religion forbids, say the eating of a particular meat. Many religions forbid eating of particular meats. And so your religion forbids the eating of a particular meat, and you want to put into your lease agreement that your tenant cannot bring that meat on premises. Is that okay to do? You know, I mean, you can put anything in an agreement. If the person agrees to it, then fine. But then
Right.
the deeper question is for a lawyer to say to you, is this some things are not legal to put into a legal agreement. And one of the only ways you figure that out sometimes is to really go to the legal profession and find out.
Yes, definitely. Yes. Yeah. So these, and sometimes there's a fine line. Your last scenario is again another interesting scenario. I mean, if I would say if your lease agreement only says that you cannot bring such and such an item, such and such a meat, or whatever it is on the premises, and you agree to that, then you agree to it. And if it leaves out anything about religion, you know, if you can't bring computers on the premises, that's that, and I know how silly that is. And the tenant agrees, then the tenant agrees. You know, I mean, yeah. So and that's it. Because, like I said, the basis is in contract. So if both parties agree, then that's what carries at the end of the day. Once you leave out anything related to religion, I mean, you can't say I'm not renting because if you are Christian, or if you are, you know, if you're a Jew, you would be disqualified, or you can't bring any Christians or Jews on the premises, things like that, you know. Because yeah, those would be discriminatory, or constitutionally discriminatory. Cleophas, I see you have a question. Oh, sorry. We're going.
Yeah,
Cleophas.
I was about to ask the same thing. I see Cleophas's hands up.
Mhm.
Cleophas? Maybe it's not up, or maybe
Okay.
it's connected.
Right. I have a question. So pretty much you can, let's say, for instance, if your belief is a Christian, you're roster, you're a Jew,
Mhm.
you can have your belief, but as a landlord, I don't have to adhere to your practices. Like, for instance, you don't want no music on Saturday or on Sunday. You can have your
No.
belief, but I don't have to adhere to your execution of your beliefs.
Correct. So I mean, Rastas will smoke marijuana. I mean, I don't want anybody smoking marijuana on my premises. So if that's what, you know, you're gonna come to my premises to do, then hey, you aren't an appropriate person for me. So if I have a block of apartments, I'll either ask. I mean, I would even ask. I probably just wouldn't rent to Rastas, because if that's a part of your religion, and I don't want the smell of weed on my premises, then you're not the appropriate person that I want to rent to. I don't think that that's constitutionally discriminatory. I just think your practice isn't well. I mean, yeah, your practice will. Well, I don't agree with that practice, or it will disrupt my other tenants, or it will disrupt me.
Yeah, interestingly enough, you see this kind of stuff in hotels, where you'll have a hotel where either the entire hotel does not allow smoking in any of the rooms, or they would only have a very small segment of the hotel with some rooms where you can smoke, and they do the same thing with pets and other things. So yeah, you can, these types of restrictions can be put in place even in an overnight setting as the hotel, where you're just not allowed to do things that should, people will think should be their free choice, but you're not allowed to do them.
And normally there's a clause in leases that say that you can't cause a nuisance, right, to the other tenants. And I think it's a wide clause. So I mean, so the question is, what is a nuisance? And I mean, if, for example, someone is outside smoking and there's the children around, and that smoke is going into another person's apartment, I mean, yeah, that you can reasonably see where that becomes a nuisance, and that the landlord may have grounds to evict the tenant, despite that being a part of that person's religion, or, you know.
So Elton, I'm gonna lead you.
Mhm.
I'm gonna lead you to the question
Mhm.
that speaks about, I found it interesting. If a lease agreement does not explicitly forbid something, what are the rights of the property owner? That's the foundation of this question. And then they gave an example. It says, for example, let's say a lease makes no mention of subleasing or other borders or about guests or numbers of guests, length of stay. Does a property owner manager have recourse if the tenant moves in, several other persons or families, even with the best of reasons?
Okay, again, yeah, it is an interesting question. So we go back to the fundamentals of contract law. So you have explicit terms or express terms, and you have implied terms. All right. So let's just say this term isn't express. So I'll say this first. So if there's no express term in the agreement about subleasing, there is a common law right to sublease. All right. Now everything should be based on reasonableness. I can sublease a acre of vacant land. The question is, can I sublease a 1-bedroom apartment? Now, if I move out of that apartment, I can probably sublease that 1-bedroom apartment. But the other provisions of the lease, like I guess the general provisions, like the tenant will be responsible for the upkeep and maintenance and all of that, right? I think too that it would be reasonable to say that it's an implied term that a 1-bedroom apartment is only or can only be rented to one family unit at a time. To bring in 3 families, I think would be outside of the scope of what the landlord thought at the time he made that contract. If you follow me, I think that's way outside the scope. If I'm renting a 1-bedroom apartment, I don't expect for a person, whether I express it in the agreement or not, to bring in 3 other families on a long-term basis. So you have 8 or 9 persons in that apartment. So I think it's fair to say that it would be an implied term that this 1-bedroom apartment is for single-family use. I think a landlord would be successful if he brings an action on that basis.
Okay. Now there's another question, just to switch to this question. As a property manager working for a property owner resides internationally and has a high-end property in the Bahamas, is it legally better for me to be a general agent to that owner or a special agent? And I guess, Mr. Gibson, you can probably, in your answer, shift us towards the difference between those 2 things. Okay.
From my understanding, a special agent is employed for a specific task. All right. And a general agent is, your task is general. There isn't any restriction basically on what you're employed to do. When I read this question, I wasn't really sure on how to answer it, because it's based on it's truly based on the circumstances, and also what what tasks the owner wants you to perform. So the owner may say to you that I only want you to do A, B, C, D. I don't know. Yeah, or he may say, I want you to handle all of my affairs in relation to this property. So that would dictate whether or not you are a special or a general agent. So let me give you an example. So the law of agency, it is broad. So powers of attorney come under the law of agency, as well as for me as an attorney or service providers. I can, for example, I can be the agent of my client. And there's a term called ostensible authority. And what that means is that I have the authority to just act on behalf of my client, to act on, without him telling me specifically to do ABC, I can do certain things without him saying, yeah, without him directing me specifically to carry out or to undertake a particular act. And especially when I'm as a real estate attorney, my client doesn't tell me, Elton, I want you to do A, B, C, D. I mean, I know what the law says. I know what to do. He hires me and I go about and I do it. So I have the general wide authority. Now, so that's let me go to a power of attorney just to make an analogy. So when you give someone a power, or you make them a doer under a power of attorney, your power of attorney can, as I said earlier, it can say that this person has a right, for example, sell a particular property, and that's it. All right. So so let's say this person can sell lot 55, Lyford Key. If that power is so that person then cannot sell lot 56. That person cannot rent that property out. That person cannot do anything besides what that specific power says. So the same way as a property manager, if you're given the power to only rent the property, you know, or whatever, you have to be sure that you're always acting within the specific language of your contract. As opposed to if you're given a general power, then I guess your power is wider. So to answer the question, I can't say which one is better. It depends on the circumstance. A specific power may be good in one circumstance because you know right away that I only have the power to do this. As opposed to a general power, you may say, well, is there a gray area? I don't know if I have a power to do this. I don't know. You follow me? So it really depends on the circumstances. Yeah, I can't say definitively which one is better, but I would say that you always need to be aware of what powers you've been given under your contract.
Yeah, in this class, we have discussed at length and gone through and prepared a management agreement, which is an agreement between the property owner and the property manager as to what their rights and obligations are to each other and what the property owner wants the manager to do and so forth and so on. This agreement, we discussed this at length. Now, there's a question here that I thought was interesting, was that whether or not, let me read the question as is there a standard in the Bahamas, whether legislation or otherwise, as to how the management agreement should be presented? And I think one of the backgrounds for asking this question is that in some jurisdictions like the United States, there are these formats for a management agreement. It's kind of standard language that one uses in a management agreement between a property owner and a property manager. And as you mentioned now, that relationship really is one of agency. So the question is there legislation? I think I'm asking this question because you seem to have hinted on this already, but is there legislation or some other standard that connects to this management agreement?
I can't say definitively, but I would say 90%. I'm 90% sure. No, that there isn't. And I think there's reason for it too. I think so the market dictates what terms should be included in these type of contracts. All right. So you are free to basically draft the terms that suit your needs. Now, so where I sit in real property law, we have a lot of precedents. That's what we go by a lot. So for certain types of transactions, a lot of our precedents came from the United States, and for other transactions, they just came from the UK. So we tend to know so let me take a step back. So Also, but it's different. It's different in a little bit, in a little ways too, because the Conveyancing Law Property Act tells us the elements of what should be included in a conveyance. All right, but of course, we have, as crafty lawyers, we've added to it. We've added to it. We added certain terms to it, so we're familiar with those terms. I would say a management agreement, there isn't any law or any standard that says what must be in it. All right, but I'm sure if you practice within that field, there are certain terms that always come to mind, you know, that you would tend to add. And this is where what the Americans will do well, is that they have these precedents that they use, because they generally cover, they generally speak and cover most instances. I would always tell people, though, a precedent is only as good as the drafter. So always be careful when you're pulling down precedents that you modify it for one use in the Bahamas and for use for your particular circumstances, because I mean, no precedent is going to completely cover your particular circumstances. So yeah.
Okay, thank you. Any questions from colleagues? And before I ask the next question that's in the list.
Right. In regards to the general versus specific, Elton, would general be covered under the reasonable man presumption, whereas your duties as a property manager could be governed by what the property owner reasonably thinks a property manager should perform, or what a property manager what powers he reasonably should have.
I would say yes. Yeah, definitely. I think that's a good metric to use when you're considering, okay, I have a general power. Is this within like if normally under normal circumstances, a property manager would have this power. I think that's a good guide. That's an excellent guide, actually, because if you act outside of that power and there's litigation on it, the court will ask you why. And of course, if your defense is reasonably, this is what property managers do within the Bahamas, and the contract was silent on it, I think that would be a good explanation and a good defense.
Right, because I mean, you have, in regards to the agreement, you can specify well in the agreement that, well, I'm doing A, B, C, and D. But under the reasonable man presumption, if a property manager in the Bahamas does E, F, G, and Y, could you be held accountable? Because I mean, it's saying for your property manager.
Now, for that, that depends on the circumstances. Now, where you have a specific, or where you have a specific duty, where your duties are listed, all right. And this says this. It depends on the wording or the drafting of the management agreement. Because, for example, it may say and no other. All right. There's also a principle in law where it says that, okay, let's say you list the duties, and another duty isn't listed, but how do I say it? It complements one of the other duties. Then that duty, even though it's not listed specifically, that would be included as well. So the contract will be construed broadly to say that one of these also includes that particular act as well. So again, it depends on the drafting. And as you say, it can depend on, I guess. I mean, I wouldn't say what's in that case, what's necessarily reasonable, because the reason why I would say that is because just because
Elton, we've lost your.
Hello, can you hear me?
Yeah, we can hear you.
Okay. Ian was saying, are you there, Ian? I think we're losing Ian. Yeah, so I mean, let me continue. No, but let's wait for Ian. Let's see if he comes back.
Ian back?
Ian? Hello? Okay, so Ian got disconnected.
Sign back in.
Okay. But yeah, we go on while Ian's missing.
Mhm.
I mean, it's an interesting, okay, whether, okay, so the question is, I guess, whether if you have a specific, specific duties under this management agreement,
Mhm.
would it be reasonable for you to say that I have, I have the power to do something that's not specified in the agreement because it is an act that property managers within the Bahamas have the right to do.
And also,
Mhm.
what owners expect of you.
Was expected. Now, if it's something that's expected by virtue of the law, then it's something that you have to do.
Mhm.
All right. So there's a law or some other duty, like maybe you give an association that says it is something that you have to do in all circumstances,
Mhm.
then you have to abide by that law or by that duty. So that's one. Now, I can think of circumstances where, even though it's reasonable, it's not allowed by the contract or by the management agreement. All right. So even though it may be reasonable for you to do, but you weren't given that special power. So this is where you need to be very careful. And if you're unsure about it, you need to seek guidance on it, either from an attorney or from the principal. You know what I mean? I mean, you see that this has to be done. I don't have the power to do this under the management agreement. You know, should I do it? Can I do it? So I think in those circumstances, it's best to go back and to and also get it in writing. Get it in writing that they're permitting you to carry out this function, even though it's silent under the management agreement. That's what I would say, just to avoid the problem of them coming back and saying no.
Right, I was saying the exact same thing, because the same as if like when you say property manager, there's expectations on twins, your end and also the owner's end. And it's best, I mean, if let's say for instance, a certain duty, you know, which is standard under the agreement, the owner doesn't want you to perform that duty, like the owner wants to collect his own rent. It has to be, you know, expressly stated that, well, you know, the owner will collect and deposit his own rent, because as a property
Right.
manager, I think under the standard, you know, you are in charge of, or you have the duty of collecting and depositing.
Right.
So yeah, you know, I wrote down that, you know, it has to be in writing that the owner has personally decided to relinquish you of that role of himself.
Exactly. Now, and as you were talking, I was thinking about a situation where, for example, let's just say you may not have the power to, I guess, to hire persons or to maintain the property, right? But let's say there's a leak, and the leak can cause serious damage, and you don't have the time to contact to contact the owner. The question is, do you act? You know what I mean? Do you bring in your serviceman or whatever? So even if your contract doesn't give you that power, and it may be reasonable to do so. You know what I mean? I don't know if you would. I don't know if as a property manager, I don't know if you would be in that, if you would reasonably be in that position. I don't know, but yeah.
But as a manager, I mean, I mean, one of your duties really is your paying maintenance and upkeep and general contracting with the property. And
Right.
so, I mean, if by chance I mean, so pretty much if that's the case, then you know, you're asked to be fair and find the best prices, you know, for the owner. So you, as a fiduciary, you asked, you know, for the owner's benefit, benefit. So, but I guess it's more like a fiduciary rule. But yeah, but normally, as I said, as I was going back to my question, you know, could you be held accountable for certain functions, you know, which are unwritten? And you answered yes. You know that, yeah.
So yeah, so go back to that. You said, can you be accountable for certain functions that aren't written? So we're just saying if you were not given a particular duty, all right, or you didn't agree to perform a particular act, and something goes wrong, you didn't perform the act, can you be held accountable? That's your question.
Right.
Oh, and that's under a general power. Right?
Right.
if a reasonable person or a reasonable property manager would have done it, then yeah, you would be held accountable.
Okay.
Yes.
Um,
I don't know if you guys want to, while we wait for Ian, another question or
Yeah, I'm
Ian's
back.
Okay. Ian's
Yeah, I'm back.
Okay.
I lost my internet for some odd
Okay.
reason, just
Okay.
disappeared on me.
Okay. All right, so okay, sorry, Ian. Go ahead.
Yes, so we can continue with the questions. I think we're on a clip to be completed by 12 o'clock instead of 1 o'clock, which is good. But we still have a number, I think about 3 or 4 questions in the list that we haven't addressed. So maybe we can just go back to the list.
I had a question too.
Okay, go on.
All right. My question is based on, I think we did this a few weeks ago in class where we were saying about regulating, like having a regulated property management board. So my question is more broader because from the legal aspect, what would it take for us to spearhead that, like to get that going in motion to say, hey, we want to be certified, we have certified property managers, and then we're going to create something where, because I think Kevin brought up a point last week where you have just random people posing as property managers just out there, but now you want something to where it has to be regulated, like almost like the real estate part where they have to be certified real estate agents in order to facilitate certain deals. We were considering starting something and putting, I guess, paperwork in or legal aspects together to say we want to create a board or create a system to where we could regulate it.
So another perspective on Cleophas's question, Alton, is what is, or is there a process to, just like you have, I think there legislation surrounding the real estate folks, surrounding contractors, surrounding engineers. What is the process, if you know and can tell us, for a group of professionals to have legislative backing for what they're doing?
Okay, I think that's another good question. So basically, the process is that I guess you meet with the Prime Minister or senior level ministers, and you convince them that this is something that is necessary for your industry, because the legislative power is of course in the government. So I know we were assisting a medical association, chiropractors, with their legislation at some point. And so one, it requires the political will of the government. If you yourself can start by drafting the legislation, and it's sometimes really, but drafting legislation is hard, but it can be easy because you may have, let's say, Jamaica or Barbados that has similar legislation. And what we do in the Bahamas is that we benchmark legislation. So we see what other jurisdiction has similar legislation. We see the parts we like, parts we don't like, and we kind of make the amendments. So that's one place I'll tell you to start. See who else with other common law jurisdiction, whether it's the UK, Canada, or in the Caribbean jurisdiction that has similar legislation. And then you would have to, like I said, get the ear of the government and just tell them that this is something that has to be done and why. And if you can get a sponsor for the legislation, that would be great. But yeah, but that's what has to happen. You have to have legislation. The realtors are excellent at it. I mean, they push and they get of course they've had their legislation for a while, but they're very organized. So they have that power to do things like that. But that's why I would say to start. Benchmark it yourself. Get an idea of what other jurisdictions do. Get copies of people comment on it. What you can do in the interim as well is that you can create a body now, or you can create a board now, and your existing board can start working on this legislation. So one, you can either incorporate a company, or you can just formalize a general association, and you can say to the government, we have an existing structure and this is how we want to be governed, but we want it to be formalized in legislation. It's always good to have an existing structure, and so the government can see that you guys are serious. You know what I mean? So yeah, that's what I would say.
Okay, thanks.
That's wonderful. All right, let me drive us back to the questions that we haven't visited. I think the second one here says, can a tenant, we kind of looked at this, can a tenant request all their funds back? There's several questions in one. Can a tenant, well, a tenant can do anything, but I let Elton answer this one. Can a tenant request all their funds back? The property manager then says, unfortunately, they cannot. If taken to court, will the tenant be in the right and reimburse what is owed, if any?
Okay, so my question would be, when you say all of their funds back, is this just a deposit or all of the funds paid under the lease agreement?
I can't remember who asked this question, but that also is something that I wasn't sure about. So whoever tended this question can probably give us a better context. Cohen, was it you?
Yes, it was me.
Okay.
I said, for instance, if a tenant is in an active lease agreement in a condo and the bank forecloses on said condo and everyone has to evacuate immediately, would they be entitled to their funds back or no?
Now, funds back, no, but when I say, okay, so basically, okay, so so let's just say that the bank forecloses today. Well, the bank forecloses today. The bank says that everybody has to give vacant possession within the next 2 weeks, and the tenant has to leave within the next 2 weeks. So the tenant should pay his rent up to that point. All right, so he's not entitled to his funds going back. All right, he should continue to pay his rent up to that point. Now, so there's a general view that if there's a breach by the landlord, all right, then the tenant may sue for damages. All right, and damages wouldn't necessarily include the return of his rent. It may include, I don't know, the cost for him to move or whatever normal damages that result in him having to pick up and actually, I guess, and to relocate. In your scenario, there's an intervening act, and it's the bank basically foreclosing. Now, neither party may have contemplated that. The landlord may have. The landlord may have, and I think I'd say this: if neither party contemplated that the bank would have, like, something would have gone wrong. I mean, there's an economic crash, and the landlord can't pay his mortgage for that reason. I would say that the landlord would not necessarily be in breach or would necessarily be accountable. If the landlord entered into the lease agreement from the beginning, knowing that the bank is on his back, you know, and he hasn't paid his mortgage, then I would say the circumstances may be a little bit different. And I mean, he goes into the agreement with full knowledge that he's going to breach the agreement at some point. So I think he would be entitled, the tenant would be entitled to damages. Now, what those damages are, of course, depends on the circumstances. But as long as the tenant stays in the lease premises for whatever period, let's say 3 months, he's entitled to pay rent for those 3 months.
Okay, thanks.
Okay, I think we've touched on this one as well. The one about if a property owner dies and probate is done by the lawyers, they find out that he has no beneficiary for his estate and has no will. can the property manager that was handling all affairs continue on the day-to-day business? What happens to the units, et cetera, legally? Is it ethical? So this is an interesting.
I'd like to, yeah, I think it's an interesting question as well. And I think, so there are a couple of things here. Firstly, where a person dies and they have no beneficiary, the state becomes that person's beneficiary. All right. So the property manager has to be very careful. They can continue to act, but this is where they need to, again, hire an attorney so that that attorney can follow up with with the Attorney General's office and advise the government that there is no beneficiary. The property manager should always, of course, keep good records, but they should, especially in these circumstances, keep good records, because any funds that he or she receives out of an arrangement like this, they would have to account to the beneficiary, which will be the government. All right. So yes, they can continue to act, but they need to seek legal advice.
I think this is a very interesting point, because as property manager, you obviously don't own the property, but if the property is certainly active, you're responsible for a condominium complex, and it's filled with people, they're all renting, and then the owner, who may be some international person, passes away. They might even be local. You're in a funny predicament, because the people can't just move out the apartment on the day that their various condos or apartments, the day the owner passes away. Rent has to still be collected and so forth and so on. But the question is, what are your rights there? This is an interesting question.
And let me just add to Ian that, so when anyone dies, they have an estate. Their estate lives on. Their estate includes their assets and their debts. So until that estate is passed on to another legal person, all of their contractual rights and responsibilities still exist within that state. So those are called choses in law. So those aren't things that are necessarily tangible. They're intangible assets, but your contracts, so all those things, they still form a part of the estate. So you still have an effective agreement that the property manager is still entitled to basically continue operating under that contract. But the property manager too has to ensure that the beneficiary of the estate, or the executor or administrator, that they communicate with that person or entity, so that they have an understanding of, I guess, what their rights would be going forward.
Yeah, and added to that, you should not have to be faced with the prospect of somebody who's a tenant saying, "Hey, I heard that so and so who owned the place died. I ain't paying no more rent." Which apparently happens in this country sometimes.
Yeah. And this is where, in your property management agreement, you should have the right. I think it's implied in certain agreements in any event, the right to I guess, because you are the agent, and as agent, you can act on behalf of your principal, who is the landlord, and you can have the right to evict. All right. So you can have those rights if there are breaches.
Okay, so let's move along. And we've touched on this one already as well. And this is a question about we are at the end of the lease. And the property owner or property manager has gone through their inspection checklist and they find everything in order. However, the question says, the company refuses to give back their security deposit. Is there any grounds to sue? And I assume this is a suit by the tenant who is expecting security deposit back.
Okay, how I read the question, if everything is in order if the agreement calls for the return of the security deposit, then definitely the tenant has a ground to sue and most likely will I guess will win. So yeah, I mean, but again, here the agreement speaks. So the property manager is bound by the terms of the agreement.
I have a question. Is there a legal must that there be a security deposit at all in these kinds of agreements?
No, I can't say I've ever seen anything. No, there isn't a legal requirement for a security deposit. It's a sensible thing to do. I mean, it's very sensible. It's practical. So yeah. But I would say this too, though. I would say that if a property manager is negotiating the terms of a lease agreement and they do not have, or they don't include a security deposit and there's damage, I think that property manager is negligent, because like I forget what Cleo was saying earlier. They were talking about what's reasonable, and what a non-property manager would do. I think it's so standard now, you know, that should be included, unless there's some other overriding reason why it's not. So unless you can explain why it's not. But I think it's reasonable to have a security deposit. It isn't necessarily illegal. Or a legal requirement, but I think it's a commercial requirement, you know.
Okay, there's a question here about while negotiating on a closing cost. So this sounds like the sale of a property. The lawyer has a better agreement, which is in the best interest of their client, who is the property owner. However, the property owner does not agree to it. The lawyer overrides the property owner's decision. Would this be classified as unethical or as fraud? Wow.
Yeah, it's a good question. Again, I think it is unethical, and it goes back to our discussion about agency and whether an attorney or an agent has the ostensible authority to override his principle. And unless he's given that specific kind of power, the answer is no. You know, unless the principle says you can do whatever you want. You can even disregard you can disregard whatever I say or my advice, which I think it doesn't happen. Unless that happens, the attorney has to follow the instructions of his client. He must. We also spoke about the trust. So a trustee doesn't have to, well, by its nature, a trustee doesn't listen to the settler. All right, the trustee, remember, has the legal estate. So unless, and I told you, there's some trusts that are drafted where the settler has a discretion. So we can make certain decisions. If that's not the case, the trustee in that arrangement has sole responsibility to make certain decisions without the right of anyone. He has that power. He also has a heavy obligation to exercise that power for the benefit of the beneficiary. So, but a lawyer doesn't have that. He doesn't have that power. No. So no, the lawyer, I mean, under no circumstance can override the decision of his client. A client can be a fool with his own property. I mean, it belongs to them.
Yeah, this is interesting, because we had a very at-length discussion among ourselves about a sort of real life situation where a property manager, where an owner of a high-end property has had an experience with a particular service provider and has said to the property manager, I don't want that person back on my place.
Mm-hmm.
But a tenant is the kind of property where persons come down from time to time who is not the owner. So they're ostensibly a tenant. So if a tenant comes to town to stay in this high-end property for a month or two, and they've had a relationship with that particular service provider, and when told by the property manager, look here, the owner said that they don't want them back on the property, the tenant says, well, I can't fathom staying here if they're not the person dealing with me. the question came up, can the property manager slip this person in the best interest of earning income and all the best interest of everything, despite what the property owner said? That was quite a discussion we had on that.
What's your view? Can someone tell me their view?
Anyone in the class could say what their view was or is, because this is a bit touchy.
Right, in terms of that question, I mean, the property manager can't really override the owner. If the owner says something is absolute. So, I mean, it's I don't even think it's discretionary. I think if you present a case to the owner and the owner, wants business, then the owner would increase. But, I think with those issues, I think the property owners, directors are absolute. And there's only so much leeway the property manager has in regards to hiring vendors which are on the bad list.
Yeah. Marjorie?
Yes, I agree, Kevin. As far as being the property manager, it's not easy to you cannot override the property owner. And in cases where you have tried, or I've seen others who have tried, you end up losing out for yourself as a property manager. So the best thing is to either convince them as best as possible if whatever it is that you're trying to do is in their best interest. And if not, then they will have to end up suffering the consequences for that particular decision. But as the property owner, there's only so much you can do unless you're giving carte blanche to do as you see fit, as Mr. Gibson had said.
Okay, yeah, thank you, Kevin and Marjorie. I do agree with both of you. And again, it goes back to the fundamental principle that you are an agent. All right, you're an agent of a principal. Your principal has so you have to carry out the will of your principal. So you don't own the property. So and yeah, so that's important.
Speaking of which, Mr. Gibson, I think we have a couple instances of this in this group. What if you are the owner and the manager? Is that okay? And how do you as a person taking on this dual role, how do you need to separate yourself as you're taking on these dual roles, or what are the pros? What are you dealing with when you decide you're going to be the owner and the manager? And in the case of one person, I know they're the owner, the manager, and a tenant.
Okay. That's interesting, because I mean, if you really think about it, most renters are owners and managers. All right, most people fall within that category because they would probably rent just the unit next to them, or if it's a duplex or whatever, right? I don't see it as conflicting at all. I think you want to bring some level of I guess some balance to your decision making. But I think when you own something, you especially when you know what you put into it to get to where it's gotten, that balance seems to fall out the window sometimes. So I mean, yes, there's nothing wrong with being both, but yeah, I like I guess when you're I guess with any business and any business decision that you want to make, I guess you want to make it with that in mind, that there's some balance, there's some some measure of equality, so yeah.
Okay, the next question, and if I record, this is Kevin's question. It talks about, and I'll read it. I was going over the pieces of legislation that covers foreign direct investments, and feel that we need to be very much aware of the authoritative bodies, NEC, Investment Authority, and the contents of the legislation in order to advise foreign clients. And he said that, so this is not a really question, it's a statement. So I guess, Kevin, I don't know if you have a particular question, because we can spend a day or two discussing foreign direct investment and the legislation around them. So is there anything in particular that you had as a question?
I mean, no, I'll just, looking at the legislation, the investment council and so on, it says that, let's say you're advising clients who want to invest in the Bahamas and who want to own property, what to tell them in regards to the requirements and, what they have to bring to the table in order to really be eligible for FDI. I know that, there's a $500,000 initial investment to get permanent residency, and also if you don't qualify for that, I think there's another requirement where if you hit a threshold that's below that, you can get certain approvals for your family. But it's just a matter of the FDI, where you have persons who own properties or who wish to own properties, what to tell them, in regards to the criteria for owning properties and investing in the Bahamas. What legislation would cover that?
Okay, so let me ask you a question before I answer that. Okay, so I know Kevin went through a mouthful there, right? Is there any like from a property manager's perspective, right? Like, what would you need to tell a foreign person relative to their properties within the Bahamas? I mean, is it your responsibility to walk them through the investment side of things, or is it?
I think it's more of a conversational tool or conversational.
I see.
No, but the answer to that is yes, because someone engages you as a property manager, they in many cases would have, and we're not talking about facilities manager. You're representing this person and their entire connection with their properties in the Bahamas.
Right.
They would. It's not out of the woods for them to expect you to be able to address questions like, you know what, I have a property here, but I want to invest in the commercial site or commercial real estate. How does this fit under the foreign direct investment legislation? So again, you at least should know enough to be able to direct them to the appropriate lawyer. And not look at them blankly and say, I don't even know what FDI is.
Right. Yeah, I agree. So this is what I would say. I would say, okay, because to my mind, the property manager, and I could correct me if I'm wrong, the property manager comes into play once the property is bought. And so now the question is, who's going to take care of this, right? But as Ian was saying just now, there are instances where the property manager may have a relationship with the property manager and may ask certain questions, and the property manager may want to have some knowledge, and I think it's great. You should have some knowledge, right? What I would say though, and this is something that as a lawyer we're always aware of. I mean, in terms of giving legal advice, and we always disclaim certain advice, right? We always say when we're not giving legal advice, we're only giving information. I would be very careful giving legal advice or giving advice generally speaking when it comes to investment, all right, especially to non-Bahamians who are very litigious, who are very smart. They're very smart, and they kind of hold on to what you say. But with that, the law with respect to foreign direct investment is scattered. So, for example, you will not see legislation that probably mentions the NEC. All right, it's not a statutory body. The Bahamas Investments Board is a statutory body, so you wouldn't see Investments Authority. I think you'd see Investments Board under the International Purchase Landholding Act. So and then you have the interplay of exchange control, and then you have a lot of Exchange Control Act, but you wouldn't see any substantive substantive rules in the Exchange Control Act. You will find them in Exchange Control regulations or Exchange Control policies. So they're there if you seek them, and if you want to define the policies. But because they're scattered, only certain attorneys, I think. I mean, well, there are a lot of attorneys that can give advice on it. But I would say you have your general knowledge, but you also direct people when it comes to legal advice to attorneys. All right, and the reason for that too is everyone's situation isn't the same, and you have to be able to understand and ask the right questions of your client to kind of place his circumstance in the right policy, in the right law, and you know what I mean. So it's tricky. It is very tricky. So that's what I would say. You have to be very, very careful when you're advising foreign clients on inward direct investments.
Now, Elton, how would the persons on this call know where to find the relevant attorney? Is there something on a boilerplate that says I'm an FDI expert, or is just, or is it okay to presume that a real estate person
Yes.
would know? I mean, how do you figure out what attorney you'd want to check with?
That's a good question too, and again, it's a minefield out there when it comes to attorneys. So, most real estate attorneys would know the basic rules. Most, all right. I'll tell you this, in my experience, you have a lot of real estate attorneys that don't know what they're doing. I'll leave it at that. But you do have great real estate attorneys out there. You have to kind of test the waters. You know what I mean? You have a lot of attorneys that have that. You want an attorney that definitely has, and you can ask these questions. I mean, have you represented non-Bahamian clients in the past? You know what I mean? I mean, you know, and I guess, like I always tell clients this too when they're looking for attorneys. Question, have a conversation. You know what I mean? I wouldn't say test them, but test them. You know what I mean? Just test them. See what they know. See how comfortable you are with the information that they're sharing. A lot of attorneys that hold themselves out to be real estate attorneys, they make some really fundamental mistakes. So you have to be careful with the attorney that you are using. Okay.
All right, I think that we may have covered all the questions I see in the list. Which is great. We've not taken up as much time as I thought that we would have. So we have time now for anything else that anyone else has to contribute or to ask while Elton's here. And so anyone?
Right. Elton, in regards to trust law and this is definitions. The executor of a will and a trustee. What's the difference between the executor and the trustee? Do they have similar roles?
That's a good question. An executor in certain circumstances has what they call a fiduciary duty, just like a trustee. All right. So, okay. So let's walk through the role of an executor. So, an executor is someone that's appointed by way of a will to administer or probate the estate of the deceased. All right. So you can look at the Probate and Administration of Estates Act that basically tells you the powers of an executor. And so one of the powers that the executor can sell the property even before the will is probated, once those funds are required, let's say to pay debts or to take care of minor children or stuff like that, right? So the executor has in that capacity, and has certain the similar powers of a trustee. So the executor, like I said, is a fiduciary, and what that means is that they have the responsibility of acting on behalf of the estate and the beneficiaries once the estate has been probated. So the executor shouldn't be acting he or she acts based on her understanding of the circumstances, but at all times he or she is acting for the benefit of the beneficiaries. So a trustee it has the same responsibility and the same obligations. They are fiduciaries as well. So in that way, both are similar.
Right. I mean, the question was made if the person dies, or let's say the owner dies, and then one of the guys saying that, one of the tenants saying that they aren't paying any more rent. But I mean, if there's no trust or no other relationship, what that fall into the lap of the executor of the will?
Well, definitely. Okay, so first, like I said, the property manager should have wide powers
Mhm.
to enforce the lease. So that's one. All right. Secondly, yes, you are definitely right. If there is an executor, the executor has the power to act on behalf of the estate. All right. Even if there isn't an executor. So of course, so you only have an executor when there's a will. All right. If there's no will, the person died would we say they died intestate, they died without a will. Then the court would appoint an administrator under the Inheritance Act. All right. Once the administrator is appointed, the administrator becomes what's called the personal representative. So they become like the executor, and that's the person that's responsible to manage the estate. So
Right.
that person can again, you can take you up. You must now take instructions from that person.
Okay.
All right.
Now, getting back to the question on discrimination and so forth and so on. So as I know profiling is a very dirty word, but we can actually, have the ability to profile clients and make a decision based on that profile, right?
Yes.
Okay.
Oh, yes. Is that your question? Yeah, yeah. I think it's reasonable to do so. I think especially in this climate, I think you definitely would want to have an understanding that this person is a right fit for not only your principal, but also if there are multiple units, yeah, they're the right fit. They're a right fit in terms of, well, firstly, can they pay? You don't want to rent the premises out to someone that cannot afford to pay the rent. So you
Right.
want to have an understanding of their ability. So I would say I've seen instances where people ask for source of funds, you know what I mean? Or they'll ask about your employment, how long have you worked there? Especially for high-end properties, if the rent is $6,000 a month, and I mean you're only making $30,000 a year, I mean, where's the rent coming from? You'd want to have an understanding of that. So I think profiling to that extent, I think is necessary.
Okay. Marjorie.
Yes, I just wanted to go back to that same, the trustee. How do we, let's say, how some families are, once there's no will in place, families begin to war and estates begin to war. How does the judge know which would be the fit, which would be the person of this warring family that would be best to make the decision for the benefit of all, as opposed to just for one individual family?
Okay, so that's a good question. Let me tell you why. As a property manager, one of your, I guess you are going to have to determine in that circumstance, even before it gets to a judge, you may have to determine who is the appropriate person to take instructions from. All right, you may have 3 or 4 persons coming at you, and the question is, who do you take instructions from? Now, one thing you may do is, I mean, you yourself, you may apply to the court, which is probably expensive to do, but to understand or ascertain who is the appropriate person. All right. What normally happens when someone dies, though, is that either there's a will. All right. If there isn't a will, then someone has to administer the estate. All right. Well, let me go back. Let me go back to the will first. So if there's a will, the will names the person who is the executor. That person is named. So you have some certainty as to, okay, this may be the person that I take instructions from. And it would be reasonable for you to take instructions from that person if a will has been given to you. Now, there could be circumstances where there's more than one will, where the will is disputed, et cetera, et cetera. This is where, again, you get legal advice, as to, okay, it's reasonable for you to take instructions from this person as opposed to the other person. Where there's an administration, so where there's an administration, where there's no will, there's no one that can act until the court appoints that person. All right. However, the Administration of Estates Act says clearly it gives you a list or a sending list of persons who are responsible for or who are entitled to apply for the estate. And you can look at the Inheritance Act at some point. So basically, and it'll tell you that if the person is married, his or her spouse is first entitled, first in line to apply for the estate. If they aren't married, then it would be their child. If they don't have a child, it would be their parent. You know what I mean? So the act tells you that. So that's another way you can be sure. If there's a trust is a document that is not recorded. So you wouldn't see that document on a public register in the Bahamas. But the person that asserts that they're trustee should be able to provide you with a copy of the trust, even in a redacted form, to say that they are the person that's appointed trustee. In the event that the trustee appointed has died, then there are documents where the trustee is transferred or a new trustee is appointed. So again, you can have some reasonable comfort that this person is the person that you should be taking instructions from. Now, you may not get it right the first time. All right. The court may ultimately say that another person is the person that is entitled to the estate or to administer the estate. But once you have done your due diligence and you've asked the right questions, if this person comes, provide me with your authority. Under what authority should I be taking instructions from you? And that person provides you with a document that you presume to be legal, all right? And you take instructions from that person. That at least covers you. Even if that's the wrong person at the end of the day, that at least covers you. You're back to the reasonable man. A reasonable person would have taken this document and said that this person has the authority, all right?
Now, Elton, I have a question there. If you are unsure in this milieu of 3 and 4 persons coming to you and making claims, and you are collecting rent, say you're dealing with a number of properties for this person, and the monthly rent collection is substantial, which can be in some cases, you might be collecting as much as $100,000 a month or more from tenants. What do you do with this collection that you're making while you are being a little confused by this one claiming that they need money from this and they need, how do you proceed?
Okay, good question. I think a reasonable property manager would have probably a trust account or an account where they separate I guess monies that they would have received from tenants. All right. I think in proceeding, you ensure that you have good accounting records to show that you are receiving these funds. If you are unsure, you don't pay the funds to anyone. And this is where you can seek legal advice first, as to, let's say, all 4 of these persons provide you with documents. All right. And you are unsure which document is correct, which document is the presiding document, which document trumps all the other documents. You definitely get legal advice, and you cover yourself with that legal advice. All right. You continue to keep those funds separate. So even if it goes to court, even if you don't pay, even if you're uncomfortable with the legal advice, or your lawyer says, you know what, we're unsure, we don't know who the appropriate person is, we have to make an application to the court. You continue holding those funds. All right. Or your lawyer would instruct you what to do with those funds, whether to pay those funds into the court, which is an option as well, until there's a determination as to who the appropriate person is. But you continue acting until the court gives the proper directions.
Thank you. Marjorie, was there something else? I think I might have interrupted you.
Oh, no. Yes, he had answered the question. I was just saying thank you.
I have a question. Ian, in regards to the liability shield, the protections, afforded to a property manager. I know we discussed the LLC, but Elton, you said the LLC and the IBC are one the same?
No, well,
I'm looking at the protections afforded the property manager in forming an LLC. Right. You had mentioned that the LLC and the IBC are similar or they're the same? Well,
okay. So the same. Okay, so in the Bahamas, our company concepts are the Companies Act, or what they call a regular company, and the International Business Companies Act, what they call the IBC. So the LLC is a little bit different. LLC it's the same thing. It's a limited liability company, but the rules regarding the LLC are different. LLC is something that is kind of in a technical sense is an American construct, right? But when you say LLC, if you use it in the lay sense of a limited liability company, then all of them are the same. All of them are limited liability companies in that there's a piece of legislation that creates an entity and gives that entity legal personality and allows that entity to act like a human being and owning property and to be sued and to be sued in its own name. All right. So the act is like the birthing legislation. When you're born, you're a person. With a company, when you're incorporated, you're a person. All right. And your certificate of registration is your birth certificate. There's evidence that you are now a legal person. So and to that extent, they are similar in that they offer the protection of limited liability. Otherwise, there are serious. There are a lot of differences, and I mean, you don't have to go into those differences now, but there are a lot of differences in terms of the execution of those different entities. But the similarity is they're legal persons. All right, they're persons. They can sue and be sued. They can own property.
Right. Now, in regards to passing the protection, of course, it's limited liability, but are there situations where the shield can be passed?
Yeah, so there are situations where the and this is so lawyers get off on this kind of stuff. I mean, if lawyers can have orgasms on legal principles, it would be passing the shield, right?
Right.
And so I would tell you this isn't something that you should be okay. But what it all boils down to though is fraud. So if the principal or the shareholder is using this company in a fraudulent way, all right, and they're acting like okay, let's just go back to take a step back. So the basic of a company is that a company is a separate legal personality from the owner. All right. So the owner doesn't so if the property owns assets, that asset isn't owned by the individual, it's owned by the company. So what the shareholder should never do is to use that asset in a way that suggests that he owns it. If he does, he is kind of perpetrating a fraud. All right. And he's not respecting the separate legal nature of that LLC, or let's call it that company. All right. So let's say he uses the asset in a way that is fraudulent. I can't think of it's fraudulent, right? So let's just say, for example, and there are cases, there are payment cases on this. He goes to the bank, right? And he tells the bank that he owns the property, but the company actually owns the property, right? That the bank gives him money based on his representation to the bank. And then the bank comes to the bank, says, we're taking the property because he hasn't paid. And he then says, no, but the property is actually owned by the company. Now, the property can be legally owned by the company. And in normal circumstances, the bank cannot breach that separate legal personality. But because he's perpetuated a fraud, all right, the courts can pierce the veil. And the courts can say, you've used this entity in a way that is fraudulent, and it kind of obscures the true nature of the circumstances. Therefore, we'll pierce the veil and we'll take the property. The bank is able to take the property from you. So, as I said, fraud is the overriding kind of principle whereby the corporate personality is pierced. Now, what I would always tell people is that if you are in a business that is risky, it's always good to also seek liability insurance, irrespective of whether or not you have a company. And the reason for that is this. Okay, so a company is capitalized by you, all right? So you would see when you look at your memorandum of association that the share capital is $5,000 divided into 5,000 shares of $1 each. The normal principle is that if someone is suing you, that capital, they can go after that share capital, which is $5,000, right? They're limited to that. In some instances, it's not necessarily passing the veil, but the court may consider that the liability is more. And if there is a breach by one of the directors, for example, the court may say that the director is liable to pay. So for example, let's say, so the director is responsible for the management of the company, not the shareholders, the directors. They're responsible for the under the act, for the management of the company. If the director is so risky, sorry, another fundamental principle is that the director is also a fiduciary. So the director, every act of the company, the director must take into account the interest of the company, and also the liquidity of the company. So if the director is reckless and he's not taking those things into consideration, he may be liable if the company is sued, and if the director breached his fiduciary duty to the company, he can then be liable. All right, so that's not piercing the veil, because piercing the veil means that it goes to the shareholder. All right, but it is an instance where not just the company, but another party that runs and manages the company may be held accountable for any negligence or whatever on the part of the company. But I would say too, like I said, look at indemnity insurance if you are in a if you are in a risky type of situation. Look for indemnity insurance.
Okay.
And this is where the association may be strong as well, because I mean with an association, the insurance companies may create create a product that's specially designed for you.
Okay, anything else from anyone? All right. Well, if there is Marjorie.
No, I just want to say thank you to Mr. Gibson
Okay.
for his time and great information. Thank you much.
Right.
You're welcome. Thank you very much. Thank you. You're welcome. My
Yes,
pleasure.
and I think I've unashamedly shared Mr. Gibson's information with you. I may have. I'm not sure that I did, but if I haven't, I will. So that if anybody feels the need to reach out to him in the future, they certainly will be able to do that. Elton, I'm really grateful for you spending a bit of your Saturday morning and now a bit of your afternoon with us. It has been very, very beneficial. We've really answered the questions that we've had, and we've gone a bit further and talked about some other things. We're happy to have had the chance to have this discussion. I know we didn't spend much time talking about ethics, but we did, and because there's law and then there's ethics. It's think about what's right and wrong to do, but may not be legal to do. And I do always advise my colleagues here that many times you cannot divorce yourself from asking the question, is this the right thing to do? Because some things are not always right to do, even if they are legal to do. But Elton, again, thank you very much. And we do wish you all the best as you proceed with your legal business.
Thank you very much. Truly appreciate it. My pleasure.
All right. Take care, and to the rest of to my colleagues on the call, do please double check that you're completing the assignments and the quizzes. We're nearing the end, so things will come feel like they're coming in a torrent, but we are nearing the end, so you'll soon have some relief from all of this work. Thank you very much, and you have a wonderful rest of the week.
Thank you, too.
Thank you.
Hey, good afternoon. Thanks very much.
Afternoon.
Good luck, guys.